I welcome you all to the third lecture of our lecture series Kayda Katta. As you all are aware, first lecture was conducted by Advocate Abhijit Sarwate sir and on examination in chief. Today we will continue with part 2 of his lecture, and I request our President Advocate Katta sir to welcome him by presenting him the flower as a token of respect and welcoming him.
Red rose.
I request Advocate Abhijit Sarwate sir to begin with this part.
Thank you. My first lecture, I'm going to just quickly recap as to what I've said on the last occasion. We began with what is the purpose of evidence in chief affidavit, and we ended in regards to beyond pleadings and what is the approach that needs to be followed. Now obviously when we are talking about cross-examination, we generally read that it's an art of cross-examination. And if I were to teach you art, I would be a magician. So obviously I can be telling you about what my experiences are and how I deal about it. Let us just begin with a few judgments. This is a recent judgment which I believe we all should read. This is a judgment passed by the Honorable Supreme Court, which is AIR Online 2023-1260. This judgment talks about a reference which has gone to the Honorable Supreme Court in regards to a very subtle difference in regards to one of the provisions of CPC. We are not going there, but it talks about what is the purpose of trial. So only two paragraphs which need to be read out from this. The first paragraph mentions the purpose of trial is to determine the validity of allegations. And when I just read through this paragraph, let us understand the role of a judge. See, the role of a judge, like we see while playing cricket, is basically to be neutral. It is not to help one party, even if the party is not represented by an able lawyer. So we'll just understand that and we'll just quickly go through what the judgment mentions. Only two paragraphs, and we'll go on to what according to me should be the thought before going for cross-examination. The purpose of trial is to determine the validity of allegations. The objective is to secure a fair and impartial administration of justice between the parties to the litigation and not the achievement of hearing wholly free from errors. Once a civil action has been instituted and issue is joined upon the pleadings, there must be a trial on issues before a judgment may be rendered. Now on the last occasion when I delivered in regards to chief, I basically said that the foundation of chief has to be issues. Evidence has to be laid only in regards to the issues that have been framed. Now this is very important. Trial is not a contest between lawyers but a presentation of facts to which the law may be applied to resolve the issues between the parties and to determine the rights. It is also not a sport. It is an inquiry into the truth in which the general public has an interest. And with this two sentences, and we'll go on to what the topic is. The judge's part in all of this is to hearken to evidence, only himself asking questions of witnesses when it is necessary to clear up any point that has been overlooked or left obscure, to see that the advocates behave themselves seemingly and keep to the rules laid down by the law, to exclude irrelevancies and discourage repetition, to make sure by wise intervention that he follows the point that the advocates are making and assess their oral, and at the end to make up the mind where the truth lies. If he goes beyond this, he drops the mental of a judge and assumes the role of an advocate, the change does not become as well. In short, it basically says that the role of a judge is at the same time not to be passive, but also to observe what is going on during cross-examinations. Now if we consider this, let us understand that there is a judgment of the Honorable Supreme Court of Zahira Sheikh, or the best bakery case. In this, the Honorable Supreme Court said that during cross-examination, the judges have to be basically active and not passive and not sleeping. Well, of course, none of the judges are sleeping, but even then, this is what was basically said, that the judges need to be paying attentive. Now, why are the judges supposed to be paying attentive or being attentive? The judges are supposed to be being attentive because irrelevancies, inadmissibilities is what the court has to decide. Now, coming to this, and after this judgment, let us quickly go, because we have only 45 minutes today, that how does a trial begin in civil proceedings or in arbitration? We all understand that the chief has been filed. Now the chief has been filed on record. We have been on the last occasion that he has sworn or not sworn or before a notary. Now let us go on to what happens after the chief has been filed. Now can there be a situation where a person says, I will not give chief and I will only come for cross-examination? Think, let us be more practical rather than theoretical. Tomorrow if a person says, I don't want to enter the witness box for the purpose of chief, but I only want to enter the witness box for being subjected to cross. Any answers on that? See, we all need to understand that someone may ask me that in civil proceedings, aren't we filing an evidence in chief affidavit? So how can this possibility arise? Let us consider in criminal law. If I were to say that I will not tender my witness for chief and he will only step into the witness box for cross, is that possible? The answer is no. The answer has to be that there can be only cross-examination if there is examination in chief. For that we can look into two judgments. One which is AIR 1942 Bombay 37 and the other is AIR 1995 Supreme Court 1601. In both of these judgments, the Honorable Supreme Court and the Honorable Bombay High Court held, there cannot be cross-examination without tendering the witness either for examination in chief or there being a chief on record. Now, could there be situations that a person has already affirmed his examination in chief, and we are doing very practical approach in regards to what happens. Let us say that for some reason a chief has been executed and for XYZ reasons the witness doesn't come or he passes away. Then what happens? This has happened in one of the famous matters of one of the leading actors in India, where a statement gave his examination in chief, he deposed before the court, and by the time the matter came up for cross-examination, he was dead. See, we may have situations tomorrow that a person falls ill or he is not in a position to come. Then what happens? His examination in chief is on record. Can you say that his examination in chief is on record, so it should be considered? So the answer is that becomes only a piece of paper. It becomes meaningless. For that, we have the Honorable Supreme Court telling us from the judgment of 1989 into bracket 3 SCC 56. 1989 into bracket 3 SCC 56, where the Honorable Supreme Court said that unless and until there has been cross-examination on the chief is meaningless. Now let us understand that how we go about through it in the trial courts, and I have seen this, I have experienced this, probably I must have also done this while I was a junior. Sometimes we file the evidence in chief affidavit and we forget a few facts, or probably we forget that after examination in chief comes the stage of proving of documents, right? So if that is the case, what do we do? Does it mean that the client has to be immediately given for cross-examination? So in that, what we can do is we can lead something which is called further evidence in chief affidavit. So the Bombay High Court says that if a chief has been given and for some reason, probably in regards to exhibition of documents or for certain other facts, if you want to lead further examination in chief, you can always do that. And this answer we find in the judgment delivered by Justice Khanwilkar, and the citation is 2008 into bracket 3 MHLJ 460, where the concept of further examination in chief has been propounded. 2008 into bracket 3 Maharashtra Law Journal, page 460. Now this is where the role of a diligent lawyer who wants to cross-examine begins. A chief has been filed, a whole set of documents have been filed, and probably the lawyer who has filed the examination in chief sends his junior and says that, sir, my client is being subjected for cross-examination. He is present, please begin with cross-examination. Now kindly appreciate the situation. The documents which have been filed along with the chief have not been exhibited. Right? So as a diligent lawyer, we need to do is that if documents have not been exhibited, according to me, and that's my practice, there may be people who may say, no, this is not the case. One should not touch those documents. Now I'll give two judgments in those regards. So that now that the chief has been filed, we are talking about about an assertion of a fact which you will find in the evidence in chief affidavit, and secondly is in regards to documents. So let's tackle the documents first, and then let's go to assertion of facts. So as I said, chief has been filed, documents have been filed, documents have not been exhibited. Now if you read this judgment which I gave you previously, which was the judgment of Rajesh Verma, which talks about further evidence in chief affidavit. The Honorable Bombay High Court way back in 2008 said that if you are proving a document, that groundwork in regards to proving of a document ought to have been in your evidence in chief affidavit. Now if you pause and if you sometimes ever see evidences, the way evidences are recorded on the original side of the Bombay High Court, which is somewhat similar to trial courts, a reference to a document and the foundation in regards to document so as to prove that document, so let it be relevancy, let it be admissibility, is a part and parcel of the examination in chief. After it is put in the examination in chief, there is one judgment which I can give it to you if I have it readily available, of Justice Gupte. The basic procedure of exhibition of a document begins. Now I am going to give you a couple of judgments which says that mere marking of a document or mere exhibition of a document does not mean that the document has been proved. Now if you see in CPC, Order 13, if I am not wrong, says that a document will be exhibited after it is proved. Now gradually we realize that what actually is written in the books and what we as trial lawyers do is absolutely different. So coming back to this, the documents have been given, the documents ought to be mentioned in the examination in chief. The documents have not been mentioned in the examination in chief. Today we are talking about cross-examination. So as a cross-examiner, if these documents have not been touched, if the documents have not been proved, please don't take cross-examination on those documents. That is rule number one. For that, you can find two judgments. One, a judgment from the Bombay High Court on the original side, which says that if the documents have not been proved, there would be no occasion to cross-examine on those documents. This is a judgment which has been passed in suit number 3523 of 2002, and the order has been passed suit number 3523 of 2002, and the judgment has been passed on 5th December 2018 by Justice G.S. Patel. Then. I'll just read out a sentence from that judgment. The production of a document will speak to the correctness of its content, but there is no law that says the document though registered cannot be disproved or its contents shown to be incorrect. Full stop. That would undoubtedly be a burden that falls on the defendant, but that burden would fall on the defendant only if the document was produced and marked in evidence to begin with. So the Bombay High Court categorically says that if a document has been filed, not proved, if that be the case, please don't touch the documents. There is another judgment if you want to note it down. It's 2021 into bracket 4 Andhra Pradesh Law Times 167. Now generally if we see that when the first appeal or the family court appeal goes to the Bombay High Court and there are final arguments, many a times these defenses have been taken that there was a bunch of documents which was filed along with the evidence in chief affidavit and the court has given it a number, or as we call it as an exhibit, and that means it stands proved. To which many a times it's argued that that would not be the case, because if a document has not been duly proved, right, and then again we have who will prove the documents, we'll just come to that. If that is the case, then as a cross-examiner, it is your duty to let go those documents. And there is absolutely no reason to touch those documents. Now there is a rider. Sometimes in the High Court, you will see, or in the Supreme Court, you will see that the judges ask you a question that were you sleeping? Not in this fashion. Were you diligent enough to raise an objection when a document was being exhibited? Why did you allow a document to be exhibited when according to you it is not proved? Now see, we need to understand that we are trial court lawyers, right? The practice here and the practice in High Court and the way the Honorable High Court deals with the situation is extremely extremely difficult, different, and their perspective of looking at things is very different. Because what they will say that we understand the law from reading order 13 or reading order 18 that the document has been marked as exhibit and that means it's proof. Now if that is the case, kindly note down these two judgments. The Honorable Supreme Court in 2010 SC Supplement 753 talks about a situation where in a proceedings an enquiry report was filed and that enquiry report was marked. As we said, it was given an exhibit, and then the matter went to the Honorable Supreme Court, and the Honorable Supreme Court said that merely marking of a document does not dispense with proof. Now we as cross-examiners, when we are about to take cross-examination, we need to understand that is a document being marked for the purpose of A, identification, or is the document being marked because it's been proved? Because if the document has been marked because it's been proved and you don't take cross-examination, then it goes against you. But if a document has been marked as an exhibit merely for the purpose of identification, then based on this judgment and two more judgments, you need not take cross-examination. Now, we all have come across these situations, at least I have come across these situations. What needs to be done? Now you need to be diligent. You need to see that before a document has been marked, whether other condition precedents for proving of that document has taken place. Because tomorrow let us say that there are averments in regards to making a document admissible, foundations in regards to the content of the document, and then the court has marked that as exhibit. Then probably you can't raise a defense that that document was marked merely for the purpose of identification. Now recently there is a judgment which came, I believe, during the COVID times, and the name of the judgment is In Re Criminal Trials. If someone has read that judgment, it's an unreported judgment. It has been authored by Justice Bobde then, the Chief Justice of the Bombay High Court. This judgment we all should read because this judgment spoke about how the trial courts need to proceed ahead with marking of the documents. One of the ways which we don't follow, which the Honorable Supreme Court has said, but then it is an argument that it is only in criminal trials and not in civil trials, basically says that you should mark a document. One with the initial P for plaintiff, R for the respondent, or D for the defendant. Then you need to mark in that same initial whether it has been given by witness number 1, witness number 2, or witness number 3. And then the exhibit number is to be given. So when these documents go to the Honorable Supreme Court, after High Court and then to the Supreme Court, the Honorable Supreme Court comes to know that this is a document which has been tendered by the prosecution witness, or by the accused, or by the plaintiff, or the defendant, whatever you call him, number 1. The Honorable Supreme Court comes to know that this document has been tendered by ABC witness, and then the exhibit number. And the Honorable Supreme Court has also said all of these documents have to begin from the number 1. So if you see in our case, we have exhibits for applications. Let us say by the time the trial begins, we have exhibits 112. And then we give the examination chief, which becomes 113. Then probably we have a section 65B certificate, which becomes 114. And then we have the documents. So there is an application for production of documents. Then is the list of documents, and then the documents begin from 116, 17, 18, 19. The Supreme Court says no. The Supreme Court says that the documents will be marked from serial number 1 and until the end. Because those are the documents which have been something which is called in Bombay High Court as tendering in evidence. What we generally do is we file a list of documents. What the terminology is that these are the documents which I have tendered in evidence. So the Honorable Supreme Court said that when you tender these documents in evidence, you will come to know and we will come to know that these are the documents which have been exhibited, on which there is supposed to be cross-examination and which have to be considered by us for passing the judgment. So I will give that citation, but you can just note down it is In Re Criminal Trials, and it is a full bench judgment of the Honorable Supreme Court authored by Justice Bobde. Coming back to this, that documents have been filed, list has been given, we have, the procedure which is followed in the family courts is just exhibits are given, exhibits are given. There is one more judgment which we can refer to as AIR 1971. AIR 1971, Supreme Court 1865. Which categorically held, mere marking of a document as an exhibit does not dispense with its proof. Mere marking of a document as an exhibit does not dispense with the proof. We are trying to understand as a role, our role as a cross-examiner. So here is a set of documents and we are coming to assertion of facts that there are documents which have been filed on record. There is no foundation. The document has been cursorily marked for the purpose of identification. And now the Supreme Court, the Honorable Supreme Court is telling us that if the documents have been merely marked as an exhibit, that does not mean that its proof is dispensed with. Unless and until you prove the content of a document, according to me, the document does not get marked. How does one do that? Now this is something, is not a part of cross-examination, but please write it down. This is a judgment which is again from the original side, which many may or not have read, but please write down this citation. It's AIR Online 2019, AIR Online 2019, Bombay 2760. Honorable Justice Dama Sheshadri Naidu, then, who is now practicing as a senior, AIR Online 2019, 2019, Bombay 2760. As students of law, we need to read this judgment. This judgment basically talks about marking of a document, production of a document, proof of a document, and who has to be examined for proving of a document. And like I mentioned, what are public documents and private documents? That portion has also been touched. Now in summation, basically we have understood that documents have been filed, documents have not been, the contents have not been proved, they have been given exhibits merely for the sake of identification, and the lawyer for the plaintiff, let us say they are the respondents or for the petitioners. So the lawyer for the petitioner or the plaintiff has not taken conscious efforts to prove the document. The role as a cross-examiner would be is to think whether the document, the contents stand true, and that is why the exhibit has been given, and if not, don't touch the document. Now many times, at least I have more seniors who have practiced much more than I have and taken much more cross-examinations. Generally speaking, it so happens that many times when you refer to a document which has not been exhibited during cross-examination, the judges say, "Tumhi ata hai cross madhe refer kele, ami ata exhibited." Right? According to me, that is wrong. There is a judgment which I'll share of Justice Kindaukar, which says that even if a document has been referred in the purpose in the cross-examination, still the proof of the content of the document is not dispensed with. So we are finished with documents. So now we know what is to be done in regards to documents. Now let us go to in regards to the facts which have been pleaded in the examination in chief affidavit. On the last occasion we concluded where we mentioned about 3 judgments. We had the judgment of Bandganga, we had the judgment of Kushawak, and we had the judgment of Dhaka. All of these 3 judgments from the Bombay High Court, all delivered by single judges, talking about striking of the pleadings. Now we have to take cross-examination. So the cross-examination, we have to see to it that we are actually taking cross-examination in regards to portions which is relevant. I began my today's discussion in regards to purpose of trial, and one of the sentences of the Honorable Supreme Court was that the purpose of the judge to preside over the proceedings is to see and to exclude irrelevancies. Now when we talk about irrelevancies, we talk about relevancies of facts. Now if there are certain assertions or certain statements which are found in the evidence in chief affidavit which are beyond pleadings, that portion, like we said on the last occasion, needs to be striked off. The basic principle of law being that evidence beyond pleadings is inadmissible. So let us say out of 15 pages of examination in chief, we are able to strike off certain pleadings that basically brings down our scope of cross-examination, and it restricts ourselves to only those many pleadings which are relevant. So those judgments which I said are mentioned in Dhaka. The name of the party is Harak Chand Gulab Chand Dhaka, and the citation is 2010 All MR, Supplement 625. We began on the last occasion by stating that the amendments to CPC came in 2002. Now, if we understand that law is always evolving, in 2002, if we got the amendment, we all knew when evidence in chief affidavits were being tendered, we exactly did not know what should be a part of the examination in chief and what should not be a part of examination in chief. But gradually over time, by this one of these judgments, which I said, which is the 2008 judgment, we came to know that if there are portions which are years. This is not evidence as is required by law. Were it to be attempted from the witness box, it would not be permitted and hence cannot be allowed to creep in merely because it happens to be placed on affidavit. So many times in evidence in chief affidavit, we have seen law is pleaded. As per section 24 asas आहे, as per section 13 asas आहे. Basic rules of pleadings is that a fact has to be pleaded. आपण तरी बऱ्याच वेळा आपण law plead करतो. But the same thing creeps in the evidence in chief affidavit also. Now imagine if someone was to write down that as per section 340 of the CRPC perjury proceedings वगैरे, and probably a question is asked कि बाबा तुम्हाला legal knowledge आहे का, तुम्ही शिकलात काय, तुम्हाला कोणी सांगितलंय, तर that person who is going to be in the witness box is going to say हे मी नाही केलंय, माझ्या वकिलांनी ड्राफ्ट केलं. Because what you are basically doing in cross examination, basically discrediting the witness. Right? That is the purpose as per section 155 of the Evidence Act. You have to discredit the witness. So please see to it that irrelevant facts are not there. Law is not needed. Something that is inadmissible is not needed, like we may have here says, is not needed. Now let us come to point number C. It is permissible and in fact often necessary for a court with a view to expedition and to avoid needlessly protracted cross-examinations on irrelevancies and matter that is not evidence, to order that any such material that does not constitute evidence to be struck off or ordered or directed to be ignored without fear of adverse consequences. So on the last occasion when we concluded, the question was whether that evidence can be struck off. So the Honorable High Court now says that that portion can be either struck off or directed to be ignored without fear of adverse consequences. So how does one do that? So basically, a chief has been filed. There are certain portions which are beyond pleadings. You go back to the judgment of Dhaka where the Honorable High Court 10, Justice Oak says, you file an application. Now why would you file an application? So that application is basically taking the form of an objection which you would raise. You have to take an objection. की साहेब हे बरोबर नाही आहे, हे साहेब असं नाही, आपण नुसतं म्हणतो साहेब ऑब्जेक्शन. आता इफ यू हॅव सीन अँड वी हॅव ऑल सीन मूवीज राईट, वी अंडरस्टँड की बऱ्याचशा फॉरेन मूवीज मध्ये किंवा फॉरेन सिरियल्स मध्ये दे ऑल्सो टेल काय ऑब्जेक्शन आहे. बऱ्याच वेळा आय हॅव सीन की जजेस विचारतात की ठीक आहे तुमचं ऑब्जेक्शन आहे, काय ऑब्जेक्शन आहे, नाही साहेब माझं ऑब्जेक्शन आहे. So that there are various objections. Probably you know in some other lecture I'll tell you कि according to me काय objections are, because unfortunately our Evidence Act or our curriculum in colleges don't teach us what objections are. कि हे objection पाहिजे, याला foundation नाही आहे, hearsay आहे, you know document बरोबर proof नाही आहे, presumption of fact आहे. All of these are there in the Evidence Act. But do you find a chapter objections? We don't find. Right? So we will come to that later. But what the Honorable High Court is saying, that you first tender an application. The moment you get a chief, you tender an application, which is an application in regards to your objections, which you put on the record, on basis of which the court has to rule. So when I say the court has to rule, when the court has to pass an order, and the court has to mark those portions. So let us say those portions are marked, right? If the court marks those portions, then that evidence is to be discarded. Now let us understand one more situation. There is one more judgment which goes back way to AIR 2001, Bombay page 187. AIR 2001, Bombay 187, where the Honorable Bombay High Court held that if a new case has been made out by the plaintiff, you need not even cross-examine on that. Now if you apply that principle of law or the ratio, why it is not applicable today is because prior to 2002, a witness would step into the witness box. Right? Today it doesn't happen. Today evidence in examination in chief is filed. So we go by the judgments which I mentioned, which was Dhaka, which was Banganga, and the judgment of delivered by Justice Soka. So now we have the portions which are striked. Right? There is one more judgment which you may note down if you want. It's the judgment part delivered by Justice Dhanuka in the matter of Rajendra Kushaba, and the citation is 2013 into bracket 6 MHLG 802, which again propounds the same point. In fact, if we read Banganga, which is delivered at a later point of time in 2015, Justice G.S. Patel mentions to all of those judgments, including the judgment of Rajendra Kushaba. So you have now basically the facts which have been discarded or which you know are not to be cross-examined on. Now that is where now you will start beginning in regards to start thinking as to cross-examination. First question you need to put yourself is, do I need to really cross-examine the witness? I have had occasions where cross-examination is taken merely for the purpose of telling the lawyer, telling the client how good you are, or how much cross-examination you have taken. Right? So the first question you need to ask yourself is, do I need to cross-examine this witness? Now why should you cross-examine the witness? You need to cross-examine the witness only in regards to facts which have come against your client. That is number one. Let us say you don't cross-examine, then what happens? Our Bombay High Court mentions that if you have not taken cross-examination on material facts, it is deemed to be admitted. That judgment is a division bench judgment of the Bombay High Court from the family court, and the name of the parties is Ganatra. I don't have the citation, but I tend to remember this judgment for obviously reasons, because we had a judge, so it becomes easy to remember. That is how you recollect judgments, otherwise So first, when we decide, do I need to really cross-examine the witness? Second question which I generally think of is that, what is my goal of cross-examination? See, if all of us as students, we log on to YouTube and we must have typed in the search bar techniques of cross-examination. We have many lawyers also talking, and they म्हणतात की witnessच्या डोळ्यात बघायचं, witnessला इकडे बघू द्यायचं नाही, असे पण आपल्याला दिसतात. So I'm not going to get into that, because at the end of the day we want answers. We don't want the त्याच्या डोळ्यात काय दिसते आपल्याला. So we want answers. So let us first understand that what is my goal. Do I want to? What is my goal? So according to me, the goal has to be only two things. One is it has to be a constructive cross-examination or a deconstructive cross-examination. but त्याच्यात आपण परत म्हणू की what kind of witness आहे, मग तो तो habitual liar witness आहे का, काय intelligent witness आहेत का. But according to me, the purpose of cross-examination is twofold. One is constructive cross-examination, where you are basically attempting to draw out helpful testimonies for your client. कि तुम्ही तुमची केस कन्स्ट्रक्ट करताय. कारण क्रॉस एक्झामिनेशन अकॉर्डिंग टू मी इज बिल्डिंग ब्लॉक बाय ब्लॉक, एक एक ब्लॉक, एक एक फॅक्ट, एक एक क्वेश्चन मध्ये. विल कम टू दैट. And the second being a deconstructive cross examination, whereby you are basically deconstructing or destroying the cross of the adversary by putting questions. So this is the only purpose of cross examination according to me. Now how do you do that? Now I was in fact discussing with Advocate Kulkarni and Advocate Zahir Khan. We have learned that cross examination is not about asking questions, but it is about understanding when to stop. Now there was a leading practitioner in US. I don't know whether he's alive or not. His name is Jerry Spence. So Jerry Spence has been one of the most successful trial court cross examiners in US for years and years. And it is his story, and I want to tell basically as to understand when to stop. And I will also tell what I have done during my heydays. Even now today I am learning, but probably in 2009-10 when I have taken cross examinations, where I have learned when to stop and when not to stop. So this story which has been told by Jerry Spence is basically about an incident of a robbery which happens in England. And the story is that some accused, or some, they call it defendant there, is stealing something, and he is accosted or apprehended by the police on the spot, and he is put for now he is being tried, and the police officer is in the witness box, and police officer ला विचारतात की तुझी उंची किती आहे. So he says I am 6 foot, say around 6 feet 1 inch. तर if we have all seen की we must have seen की इंग्लंड मध्ये बॉबी असतो, त्याला असं वरती जो हे असते, so ते पण तू घालायचा का, तुम्हाला हो घालायचो. So तेव्हा तुझी इंच हाईट किती व्हायची, तुम्हाला अराउंड 6 feet 6 inches or 6 feet 7 inches. Now imagine कुठलाही चोर कुठल्या घटनास्थळी चोरी करतोय आणि त्याला इमिजिएटली पोलिसांनी पकडलंय, एक ॲली आहे, तर ऑब्व्हियसली त्याला गोष्टी ऐकू येतील, तर ही लाईन ऑफ क्रॉस एक्झामिनेशन चालू होती. तर तो म्हणाला की अंधार होता का, तो म्हणाला नाही एवढा अंधार होता तिकडे. सो तुमची बिल्ड कशी आहे, तो म्हणाला ऑब्व्हियसली माझी बिल्ड चांगली आहे. सो ही वॉज ट्राइंग टू मेक इट इम्प्रॉबेबल की असं होणंच शक्य नव्हतं की तो माणूस इकडे चोरी करतोय आणि तुम्ही समजा येत असता त्याला कळणार नाही. बरोबर. दिस वॉज द लाईन ऑफ क्रॉस एक्झामिनेशन. तर आपल्याला हे पण माहिती की आपण बऱ्याच वेळा बघतो when we see की the police officers outside Buckingham Palace, most of them are on a horse, right? So there also he says that generally don't you have horses. We are talking of probably 1970s ka 60s the example hai. So he is saying that generally aren't you galloping on a horse. So ते म्हणाले बरोबर आहे, मग आपल्याला हे पण माहिती की घोडा आवाज काढणार, right? So all these are things which are being put on record to show कि it is improbable कि तुम्ही त्याला actually on the spot पकडलं. हे सगळं होतं आणि young cross examiner आहे, Jerry Spence is sitting somewhere behind and he is saying wow, such a young lad taking such fabulous cross examinations, and you stop there, right? And you stop there, and that is where we go back to the first judgment which I mentioned. The duty of the judge is to decide based on the evidence that has come on record. So what we say is that conclusions have to be drawn by the judge. आपण फक्त पिक्चर मध्ये बघतो की कुठला तरी विटनेस इन द टेस्ट इन द बॉक्सेस, हाँ मैंने खून किया, मैंने ये किया, मैंने वो किया. It never happens in real life. Now if we put this and consider the illustration which I gave, an accused trying to steal something, there is this police officer who is supposedly on a horse, horse आहे प्लस त्याच्यावरती तो 6 फूट 4 इंचाचा आहे, तो येतोय. Is there a possibility that he will arrest him and the accused will be there on the spot? तर हे सगळं होतं आणि fabulous cross examination. Jerry Spence who is listening to the cross examination says अरे किती सुरेख झाली. आणि मग हा यंग लॉयर त्याला प्रश्न विचारतो की हे सगळं असताना how is it possible की तुम्ही त्याला अरेस्ट केलं. तो म्हणाला त्या दिवशी मी सायकल करत होतो. And kindly imagine the entire cross is destroyed. So what we need to learn is what not to ask rather than what to ask. What to ask हे आपण automatically येणार आहे, right? But not what to ask. कारण मी म्हटल्यासारखं की conclusions have to be drawn by the judge, not by the witness. You stop at a point of the cross-examination where you can pitch at the time of closing argument की साहेब असं असं झालं ना म्हणजेच हा inferences to be drawn. 2010 मध्ये मी एका ठिकाणी क्रॉस घेत होतो आणि हस्बंड वाईफचा डिस्प्यूट होता and my decision to cross-examine was with the purpose की in case there was a flat on which there was some encumbrance होता आणि माझा असा विचार होता क्रॉस मध्ये की I will ask the husband that tomorrow if you lose a particular case the property will be attached. असं मला conclusion त्या husband कडनं draw करायचं होतं and I asked him a question की if you lose this case कुठला तरी specific performance चा दुसऱ्याने दावा लावला होता in regards to one house and if you lose the house would go. So I asked him a question that if you lose do you know what will happen? So I was hoping कि okay, I have nailed him. कारण मला उत्तर मिळणार. तुम्हाला हो मला माहिती आहे मी काय करीन. I said काय? म्हणे मी अपील कोर्टात आहे. So these things happen, right? So I was like, oh yeah, you're correct. बरोबर आहे. आणि मला परत बाकीच्या गोष्टी विचारायला लागल्या. So when we do cross examination, right? I have always, told my juniors कि take a vow, right? Take a vow कि तुम्ही 4 गोष्टी विचारणार नाही. And the rule is WWWH हे तुम्ही कधीच विचारणार नाही. म्हणजे काय? तर when, where, what आणि how या क्रॉस एक्झामिनेशन मध्ये विचारायच्याच नाही. तुम्ही when म्हटलं की तो काही म्हणू शकतो. मग नंतर काय केलं आपण बऱ्याच वेळ बघतो क्रिमिनल मॅटर्स मध्ये पुढे काय झालं कुठला विटनेस म्हणू शकतो की पुढे साहेब मी थकलो पुढे काय झालं हो मग मी चहा प्यायला गेलो राईट ऑब्वियसली हा चीफचा भाग झाला. But cross examination मध्ये as I said it is your building block by block. Please cross examiners throughout India will ever say that कि मला art माहिती आहे. So when you discredit a witness, what you basically do is you basically do three things. One, you show he is unworthy of credit. You basically show corrupt inducement to give evidence. I am reading section 155. And you can also do that by proof of former statement. A proof of former statement तुम्हाला माहिती आहे की contradictions असतात किंवा omissions असतात. That is you do. Corrupt inducement to give evidence where you show relations or sometimes you show कि hostile witnesses असतात. Criminal matters, not hostile witnesses. Regular witnesses असतात, पंच असतात. तेच परत येतात. And then unworthy of credit. Now unworthy of credit is you have to basically discredit the witness. How you can do it is something which we can't be talking now. How to prepare for a cross examination? Now this is something which we need to learn. We can't be discussing this But as I said, if we start thinking, and like I read the first judgment is you're basically telling your story. Now if you're telling your story has to be found in your pleadings. ही तुमची story आहे, right? So तुमची story आहे समोरच्याची आहे. मग तुम्ही तुमची story put up करताय. So what you are doing it is, how you are doing it is you are basically putting a leading question. A leading question which has an answer. You are putting it one by one. You are basically building your case by putting one block to the other. Second question has to be somewhat related with the first question. Third has to be somewhat related with the second and first, and then so on and so forth. Now, what is the role of a judge in that? The last time also we discussed. We also discussed that tomorrow if you were to ask certain questions, and if they get overruled or if they are objected upon, what is it that you should be doing as a lawyer? Many times I have seen कि बऱ्याच वेळा judges म्हणतात की next question. And especially for lawyers who practice in the family court, section 15 of the Family Courts Act, मला वाटतं refer करण्यात येतो. Section 15 of the Family Courts Act, if I am not wrong, talks about the way in which the testimony is to be recorded. Summary in nature. Now when we talk about summary in nature, it doesn't mean कि तुम्ही विचारलेले प्रश्नच घ्यायचे नाही. It only says कि तुम्ही तो प्रश्न विचारला तर लगेचच त्या जजनी घ्यायला पाहिजे असं नाही. What the judge should do is the judge should allow you to ask 5-6 questions and then summarize it and then put it in the deposition. बऱ्याच वेळा जजेस काय म्हणतात? जजेस म्हणतात की नाही आपले समरी प्रोसिडिंग्स आहेत ना तर तुम्ही पुढचा विचारा. तुम्ही पुढचा विचारला हे absolutely बरोबर आहे. These directions are given, like I said, the judges have to be active, they can't be passive while recording cross examination. That doesn't mean that तुम्हाला सांगण्यात आलंय की बाबा पुढचा प्रश्न विचारा, म्हणजे तुम्ही पहिला विचारलेला प्रश्न, दुसरा विचारलेला प्रश्न किंवा तिसरा विचारलेल्या प्रश्नांची आलेली उत्तर रेकॉर्डवर घेतली. So as a lawyer, as a diligent lawyer, when you are taking cross examination, please see to it that you have asked a question, and if that question has been answered and if the judge says please ask the next question, remind the court that I will ask the question, but please see to it that if that answer comes on record. Right? Now if the judge is not taking the answers on the record, right, then what is it that we can do? Now the CPC or the civil manual, for that reason, especially if we see the civil manual मध्ये rule 255 बघा please. Section rule 255 of the civil manual talks about two things. It talks about the duties of the judge and the role of the judge to check random and pointless cross-examination, and also to ask the examiner to explain the relevancy of a line of inquiry when apparently it has no bearing upon the case. हायकोर्टामध्ये तुम्ही बऱ्याच वेळा ओरिजिनल साइडचा करता किंवा बऱ्याच वेळा तुम्ही जेव्हा आर्बिट्रेशन करता तेव्हा तुम्ही समजा कुठला प्रश्न विचारला आणि आपल्याला विचारलं जजनी ह्या रेलेव्हंट काय आहे, तर आपण काय करतो? आपण त्याचं उत्तर देतो, राईट? आपण त्याचं उत्तर देतो तेव्हा विटनेस हा विटनेस बॉक्स मध्येच असतो, राईट? व्हॉट इज द पर्पस? ही इज गोइंग टू कम टू नो. कारण आपण इनडायरेक्टली आपण जजला सांगणार आहे की फ्रॉम ए क्वेश्चन टू झेड क्वेश्चन इज व्हेरी लीडिंग. So in that case, you need to tell the witness to be excused for a few minutes, have him go outside the court, and then you deliberate. आपण हे करतच नाही. आपण काय करतो? साहेब हे असं असं आहे, मी असं असं करणार आहे. Most of the clients are already well read. इंडिया कानून, लाईव्ह लॉ. We know आपल्याला 100 प्रश्न विचारतात की असं का नाही, असं का नाही. मग असं असतं तर those witnesses are going to be well read. If you are going to tell them की ही माझी line of cross examination because the judge is asking you a query, so you are trying to tell that query की असं असं आहे. What is the purpose? Because if your purpose is to discredit a witness, if you are going to tell him that this is my line of cross-examination, any intelligent witness, and we say that all would be intelligent in today's age, considering technology, is never going to give us an answer. So these are, according to me, a basic few facets of cross-examination, which I generally follow. If it is an art, obviously, as I said, I am not a magician. I can only tell you 45 minutes is something which is a very small time. As a junior, I have heard lectures of seniors talking about contradiction, omission. We need to discuss that, but probably sometime in some other sessions. अजून बाकीच्या काय गोष्टी करता येतील क्रॉस मध्ये अजून खूप टॉपिक्स आहेत. लाईक आय सेड इट इज नेव्हर एंडिंग. अकॉर्डिंग टू मी इफ आय वर टू टॉक प्रॉब्ली टू टेक 5-6 आवर्स. आपल्याला आपण पण कंटाळला असाल, मी पण कंटाळणार आहे एवढ्या वेळाने. सो आय थिंक आय विल एंड हियर. आय होप काही क्वेश्चन्स असतील तर आय ट्राय माय लेवल बेस्ट. That is what you decide as a diligent lawyer. Yes.
It's not a law.
It is the law.
It is the law.
Yes.
So in that case, I have to bring the author of the document first, and I have to prove that document. Then the witness has to.
Yes. So that is why I gave that document of passed by then Justice Dhamma Sheshadri Naidu, and I refer to section 136. Let's read section 136. 136 of the Evidence Act, and we are referring to the old. त्याच्यात proviso आपण कधीच वाचत नाही. Let's read section 136 proviso clause. See, section 136 of the Evidence Act मध्ये illustration दिले in regards to proving of a will. I'll just read out the proviso clause. If the fact proposed to be proved is one of which evidence is admissible only on proof of some other fact. So again, if you are proving a fact which is only admissible on proof of some other fact, such last mentioned fact must be proved before evidence is given of the first mentioned. Let us say there is a document and you want to not touch the document, and according to you the author of the document has not been examined, right? So in examination in chief, according to you, you should have this tentatively marked, and you find this day in day out in high courts. High court's original side la. The document is marked tentatively as exhibit so and so into bracket subject to proof by author or so and so so and so so and so. So it is tentatively marked, right? It is not happening in trial court. So we need to tell that this is.
You are a witness in a witness box. If all the document is concerning you, or you are the author, or you are the writer, or it is your handwriting, then you have to make it exhibited.
Yes.
If all it is written by him,
Third person.
and he is the signatory, in your chief examination, this cannot be exhibited,
Yes.
considering the fact that you are not the author.
I got
So
that.
merely referring the document in the chief
Will not be sufficient.
Will not be sufficient.
What sir said, if it is not exhibited, if it is not proved, you should not take cross-examination.
Karan, now talk. In your examination, if this letter has been produced on record and your chief is there.
Yes.
Now, this has not been referred to in the chief at all. You have not referred to this particular document in the chief at all. In that case, in the cross-examination, I need not touch
That's
that
the
document.
document. Even if it is referred, it will not be proved, na?
Yeah, even if I need not touch that
That's the
document.
document.
In the cross, I need not cross-examine you on that document, which is this document.
See, now let us understand how it should legally go, right? Let us say, as Sir has said, that there is a letter which has been written by me. You are the plaintiff, I am a third person, right? And there is another person. So, in your chief, there is a reference to a letter, right? You say, I will exhibit kara. Sahib mantat nahi, we will not exhibit the document because you are not the author of the letter, right? Now, as a cross-examiner, I am supposed to do two things. One, as an examination in chief, you are supposed to say, I will tentatively mark kara as per 136 proviso clause. So, it gets tentatively marked into bracket. Ki baba will be exhibited subject to proof and so and so. You can reserve your cross-examination. आपण म्हणू शकतो साहेब till it is proved मला कायदा म्हणतोय I don't have to cross examine, so I will reserve my cross examination to a future date because tomorrow you may not call the witness. What if you forget? If you don't call me, the author of the letter, that document is not proved, so I will not cross examine that. Let us say tomorrow you forget to call me, काय बाकीचे witnesses केले मला विसरून गेला, that document stands unproved. Let us say you call me as a witness and then the document stands proved, right? That time my cross will be taken. You can also make an application, now I want to call you.
Again.
Obviously, because now it stands proved.
So isn't it too complicated?
But तसंच आहे ना, that is how the law is. We all have shortcuts. आपण सगळे shortcut मानतो ना. If we go strictly by Evidence Act, it makes the situation.
So in every case, we have to first call the witness and prove the document, and then
That is why on the last occasion when I gave this example in regards to will, मी willचं example दिलं की will ला आधी कोणाला आणायला लागतं? आपल्याकडे तो ऍप्लिकंट असतो तो विटनेस बॉक्स मध्ये येतो. जस्टिस जी.एस. पटेल सेड नो, if you are having a testamentary petition, we आपण succession certificate म्हणा, a letter of administration म्हणा, based on the will, तर will कशी prove होते? By examining the witnesses, right? तुम्हाला आधी त्यांना आणायला लागतं. So now Justice Patel has said, you don't have to step into the witness box because let us say you are an executor of the will. तुम्हाला माहित पण नाही ना, तुमचं नाव लिहिलंय की बाबा in case of my device XYZ will be the executor of the will. Executor of the will you काय करणार आहे? The will is not proved. That is why Justice Patel has said, first let us examine the witnesses. After the witnesses are examined, witnesses to the will, right? Then we know that now that the will has been examined, then you can take cross-examination. So that is why when on the last occasion when we mentioned about Order 18 Rule 3, right? Sequence of witnesses. Tomorrow if your entire case is based on one document, let us say just on one document, फारच काहीतरी त्याच्यात आहे, there are defamatory per se, cruelty per se, something which doesn't require any other elaboration or arguments, right? You can then decide, you can make an application कि साहेब हे document माझा कुठली एक आहे, it's my trump card, I want to examine this witness and then I want to examine the other. It is based on the skill how you convince the court.
Judges they ask us to make an application, then
Or
there is other
application,
side.
but application कराच
Then I
करा
said
ना.
that
Order 18 Rule 3 चा leave has to be taken of the court, so you have to make an
Then
application.
why other side to say when the law says that you have right to call the witness first, then why
But
other
that
side?
is right, other side नाही व्हायला पाहिजे because it is your
But
prerogative.
generally होतो argument होतो आणि त्यानंतर order.
You have to give list of witnesses.
ते तर आहे last time which you have said.
Witnesses, call you have calling for the witnesses. Witness summons has to be.
It's a म्हणणे sequence of witnesses.
Like आता sequence मला दुसरा I want to examine second witness first before me. Then in that case, yes, I have to make an application. Then why there is other side to say when law says that you can call a witness before yourself?
Because we have an adversarial system. आपल्याकडे adjournmentला पण other side to say करतात ना, party नसली तरी. बऱ्याच वेळा नसतात तरी other side to say करतात. आपण 5 वाजेपर्यंत थांबतो.
सगळ्याला other side to say. सगळ्यालाच.
Expert application other side.
पुरुषीस्वर तर other side to say.
These are things which we face as lawyers. So मी माझं तर असं प्रामाणिक म्हणणं आहे की because when I go to the Supreme Court, I find youngsters extremely knowledgeable. You know what probably I came to know after 20-25 years of practice. त्यांना चौथ्या तिसऱ्या वर्षातच कळतं. The only thing I distinguish myself is मला थोडा experience आहे. Knowledge I may not have. So the youngsters should know की knowledge तुम्हाला कुठल्याही वर्षी येऊ शकतं. Experience तुम्हाला थोडे केस पांढरे झाले. No questions for cross examination. एखादा तर प्रश्न आहे मला पण ऍटलीस्ट कळेल ना मला पण काय हे करता येते का
सजेशन द्यायला पाहिजे तर.
हो येस तुम्ही ना आता टेक डाऊन दिस आपण आज ऍक्च्युअली रॅप्ट आपण वाचलं असलं तर एक जस्टिस पार्थिवाला त्या ऑनरेबल सुप्रीम कोर्ट मध्ये who's been elevated from Gujarat High Court who want to become the next chief justice पुढल्याच्या त्यांनी एक रिसेंट जजमेंट दिलंय in regards to suggestions. Criminal Appeal number 1910/2010. Criminal Appeal 1910/2010. Recent judgment है 2023 चा. And if I am not wrong, this judgment has gone from Pune Sessions Court's matter है. आणि त्या मॅटर मध्ये कोर्टाने तुम्ही किती चुकीची क्रॉस घेताय असं लिहिलं. त्या ह्याच्यामध्ये तुम्ही त्याच्यातले काय काय पॅरास आहेत प्लीज रीड दिस जजमेंट आणि त्याच्यात सजेशन्स बद्दल सी सजेशन्सचा पर्पज टू फोल्ड आहे देयर इज ओनली वन इकडे सजेशन इज बेसिकली व्हेन यू पुट युअर केस द पर्पज ऑफ सजेशन इज यू हॅव टू पुट युअर केस. तुमची ती काय केस असेल यू नो मग तुम्ही म्हणाल की बाबा टेकिंग ॲडव्हान्टेज ऑफ हिज ओन रॉंग वगैरे वगैरे दॅट हॅज टू बी डन अकॉर्डिंग टू मी इट हॅज टू बी डन. देयर आर जजमेंट्स It goes way back to 1963 मध्ये क्लॅरिएट म्हणून एक जजमेंट आहे कॅलकटा हायकोर्टाचं प्लीज वाचा त्याच्यात त्या जजमेंट मध्ये अँड देन दिस इश्यू केम अप अगेन बिफोर जस्टिस पटेल कारण ओरिजिनल साइडला जस्टिस पटेल बरेच वर्ष होते त्यांनी पण हे केलं की यू हॅव टू पुट युअर केस. आता बऱ्याच वेळा आपण बघतो आणि की आपण म्हणतो साहेब मला माझं एंटायर रिटन स्टेटमेंट आय वॉन्ट टू पुट इट की मग हे खोटं आहे हा पॅरा खोटा आहे हा पॅरा खोटा आहे हा पॅरा खोटा आहे. सो डिनायल्स जास्ती असतात आणि as such cross examination कमी असते. That according to me is not necessary. You need to have it clarified at the start. बऱ्याच वेळा arbitrations मध्ये तुम्ही हे करता, there is note is made that specific denial of every fact is being dispensed with. कारण उद्या someone can say की साहेब यांनी या पॉइंट वरती डिनायल घेतलाय की साहेब मी म्हटलं सर की गणतराव असं गणतरावचे जजमेंट आहे त्याच्यात लिहिलंय की if there is no cross examination it is deemed to be admitted or an adverse inference is to be drawn. तेच in fact one of the कानगंगामध्ये पण तेच दिलंय. मग अशा याच्यामध्ये you need to be very clear की you need to tell the court की साहेब मी प्रत्येक डिनायल नाही घेणार आहे पण please make a note that my one denial will be construed as denial through for the entire affidavit.
But sir, I have read what, sorry.
It says that in case of civil matters, the suggestions are not necessary. In case of criminal matters, there is always a case of prosecution. Defense has no
Foundation.
entire CRPC has nothing to do with the defense of the writing money defense. So you have to have some theme. If you are taking a view of enemy, then you have to give suggestion that on Tera he was at Calcutta and on that day he was at such and such place. So suggestions are necessary in criminal matters. In case of civil matters, there is a plaint and there is a written statement in the form of defense. So there is already a defense. In criminal law, there is no provision where
Pleadings नसतात in form of defense. Yes.
So defense ला तुम्हाला सजेशन देणं मागे सिव्हिल मॅटर्स मध्ये सजेशन देणं गरज नाही याचं कारण म्हणजे तुमचा डिफेन्स इन द फॉर्म ऑफ रिटन स्टेटमेंट इज ऑलरेडी ऑन रेकॉर्ड. सो माझं असं म्हणणं म्हणून जे देतात ते
You basically according what I do is I basically in the last paragraph I summarize it in 4 or 5 sentences. You need not give each and every, but according to it needs to be done. आपल्याला सर म्हणाले विल ऑल्सो रीड दॅट जजमेंट कारण परत स्ट्रेंथ वरती फरक पडतो. सिंगल जजचा आहे, डिव्हिजन बेंचचा आहे का सुप्रीम कोर्टचा आहे. तर हा मी म्हटलो क्लॅरिएट म्हणून ते जजमेंट आहे which basically spoke about Calcutta and I mentioned about Justice G.S. Patel. हे सिंगल जजेस आहेत इकडे.
त्याच्यामध्ये जजमेंट मधलं वाक्य एकच आहे, दिस इज द सजेशन्स द फॅशन हॅज बीन इम्पोर्टेड बाय क्रिमिनल लॉयर्स इन सिव्हिल मॅटर्स. हे जजमेंट मधलं वाक्य आहे, दिस इज इम्पोर्टेड बाय क्रिमिनल लॉयर्स इन सिव्हिल मॅटर्स. कारण क्रिमिनल लॉयर जेव्हा
putting your case
सिव्हिल मॅटर मध्ये क्रॉस देतो तेव्हा ही ट्रायज टू पुट सजेशन्स.
सर आता या ठिकाणी आपण कायदा पाडला क्रॉसच्या बाबतीत जो कायदा आहे पण एखाद्याला इंटेलिजंट विटनेस असेल त्याला सायकोलॉजिकली तोडायचे तर ती आर्ट्स का आहे. आता कायदा हे तर ठीक आहे नाव जी एखादी आर्ट आहे त्याच्या अनुभवाने त्या आर्ट बद्दल तुम्ही काय शिकणार आम्हाला काय
बरोबर.
त्याला कसं सायकोलॉजिकली तोडायचं कसं काय
म्हणून आपल्याला YouTube वरती बघायला लागतं आखो मेरे. See that's an art ना. तुम्ही कसं तोडता सी प्रत्येका विटनेसला काहीतरी एक लूपहोल असतो. प्रत्येका विटनेसला काही ना काही एक प्रॉब्लेम काहीतरी कुठे ना कुठे काहीतरी असतं ना. सो यू डू दॅट लाईक म्हटलं तर डिस्क्रेडिट करायला विटनेसला मग 100 गोष्टी आहेत ना. आता तुम्ही कसं डिस्क्रेडिट कराल बेस्ड ऑन फॅक्च्युअल सिच्युएशन.
ते इतके पाठांतर करून चालले असं चान्सच नसतो आपल्याला.
काय होतं माहितीये का काय होतं तुमची कला आहे इकडे बऱ्याच वेळेला असं पाठांतर करतात ना तेव्हा मी असं बऱ्याच वेळा केलंय आणि मी कधी कोर्ट्स हॅव कन्सिडर्ड दॅट नॉट कन्सिडर्ड दॅट. तो खूप पाठ करून येतो ना त्याला मग बेसिक कधी गोष्टी विचाराव्या की बाबा आधारचा नंबर काय तुम्हाला माहिती आहे आधारचा नंबर 16 डिजिटची आपल्याला नाही आपल्याकडे सगळ्यांकडे आधार आहे राईट. मग तुम्ही अशा गोष्टी विचारल्या ना तुम्हाला कळतं की अरे त्यांनी ते पाठ केले म्हणून त्याला गोष्टी माहिती आहे पण त्या तुझ्या खिशात आहे तुझ्याकडे ड्रायव्हिंग लायसन्स आहे त्याचा काय नंबर आहे विचार करा माहित असतात ना आपल्याला त्याच्यावर
रिलेव्हन्सी असली पाहिजे
आहे ना. आपण डिस्क्रेडिट करताय ना विटनेसला आपण म्हणतो सजेशन द्या की तुम्ही पाठांतर केलंय बाकीच्या तुम्हाला गोष्टी सी शेवटी ही कला आहे ना आर्ट आहे ना. सो देयर आर वेज यू नीड टू अंडरस्टँड. म्हणून तर युअर क्लायंट नीड्स टू टेल यू ना की बाबा हा हुशार क्लायंट आहे हा काय कधी अवघड अगदी अनइंटेलिजंट क्लायंट जास्ती अवघड जातात कारण आपल्याला तसा आन्सर पाहिजे तसंच मिळते त्यांच्याकडनं. तो सेन असतो तो बरोबर उत्तर देतो नॉर्मल असतो तो पण ते अनइंटेलिजंट असतात ते उत्तरच देते काहीतरी भलतंच देतात.
त्यांचं स्टँडर्ड उत्तर असतं आय डोंट रिमेंबर तसं एक उत्तर असते आणि आपण
पण आय डोंट रिमेंबर वरती पण ना जजमेंट्स आहेत. इनफॅक्ट या जजमेंट मध्ये पण बघा त्याच्यात की प्रत्येक गोष्टीला आय डोंट रिमेंबर असू शकत आहे ना. उद्या तुम्ही म्हणाला की सो दॅट इज व्हेरी क्लिअर. आता यांनी प्रश्न विचारला हा इव्हेसिव्ह आन्सर्स आय डोंट नो म्हटलं तर कुठल्या गोष्टी आता तुम्ही चीफ मध्ये अगदी सगळं बोलता, अगदी तारखा सांगता काय झालं, आणि मग तुम्ही क्रॉस मध्ये म्हटल्यावर आय डोंट नो म्हणता. दॅट इज टू बी आर्ग्यूड ना फायनली. इकडे तेरा पण एक दोन जजमेंट्स आहेत, पण देन वी नीड टू सी this is what we generally face, right? इकडे but the bottom line is that as I said की conclusions have to be drawn by the judge. आपण बऱ्याच वेळा काय करतो, आपण बऱ्याच वेळा YouTube वरती बघतो की वकील भांडायला लागतात, एकामेकांमध्ये भांडतात आणि विटनेस बरोबर भांडतात, राईट? कन्क्लुजन हा शेवटी जज देणार ना, त्याच्यामुळे यू लीव इट एट अ पॉइंट वेअर यू कॅन आर्ग्यू अ केस. आपल्याला स्टँडर्ड्स माहिती आहेत ना, आपल्याला बियॉन्ड रिझनेबल डाऊट आणि प्रीपॉन्डरन्स ऑफ प्रॉबॅबिलिटी वरतीच खेळायचं ना शेवटी. इज इट प्रॉबेबल ना?
त्यासाठी आपल्याला जेनेटिक सायकोलॉजी माहित पाहिजे,
व्हेरी ट्रू,
नॉलेज माहित पाहिजे. आणि ज्याच्यात आपला
senior lawyers will tell you more than knowing the law, know the judge.
सायकोलॉजी माहित पाहिजे, विटनेस कोण आहे, काय जज काय, सायकोलॉजी काय, जज कसा डील करतो.
आपल्या कंट्रीज मध्ये आपल्याला लेक्सस टेक्सस माहिती आहे, इंडियामध्ये पण आहे, पण इफ यू गो अब्रॉड आणि अब्रॉडचे तुम्ही लेक्सस टेक्सस बघितले तर ट्रायल कोर्टचे पण त्यांच्याकडे डिपॉझिशन्स असतात त्या साईटवरती. तुम्हाला कुठल्या केसमध्ये कुठला विटनेस आला हे पण तुम्हाला कळतं. आपण समजा बघायला गेलो तर आपण बऱ्याचशा क्रिमिनल लॉज मध्ये, क्रिमिनल ट्रायल्स मध्ये तुम्ही म्हणता की तो हॅबिच्युअल पंच आहे, राईट? बट तुम्हाला दाखवायला काहीच नसतं. तुम्ही दरवेळी येतो, तो विटनेस म्हणतो नाही आणि तो खराच आला असतो. तर अशा पण काय काय गोष्टी आहेत, साईट्स आहेत. आपल्याकडे यू कॅन डू व्हेरियस रिसर्चेस. तुम्ही जाऊन पोलिसांशी बोलू शकता, यू कॅन फाइंड आउट की या कोर्टात चालू आहे. तुम्ही क्लर्कला विचारू शकता हा विटनेस कधी आलाय का. बऱ्याचशा तुम्हाला क्लर्क पण सांगेल की हा विटनेसनं कमीत कमी 3-4 मॅटर्स मध्ये येऊन गेला. सो दीज आर ऑल्सो वेज ना टू डिस्क्रेडिट अ विटनेस. सो सी हे कसं आहे, दिस इज व्हॉट यू कम टू नो ग्रॅज्युअली इकडे. पण देर आर थिंग्स यू नो, देर आर AI ऍप्स आहेत, बाकीच्या काय काय गोष्टी आहेत, वेर यू कॅन कम टू नो. मग एक्सपर्ट विटनेसेसच्या टेस्टिंग कशा हे करायच्या वगैरे. That is advanced. आज आपण basically we are catering to people who are probably from 1 year of practice to 5 years of practice, right? मला वाटतं seniors-ला सांगायची गरज नाहीये. There is nothing novel or unique which I told, but this is basically to cater to people who are from 1 year to 5 years who want to at least understand how I begin with. So तेवढ्यासाठी ठीक आहे. Thank you.
धन्यवाद सर. अतिशय चांगल्या भाषामध्ये आपल्या ज्युनियरला समजत अशी तुम्ही माहिती दिली, त्याचा फायदा नक्कीच आपल्या सर्व वकिलांना होईल. कारण आजच्या या लेक्चरची बऱ्याच वकिलांनी डिमांड केलेली होती, म्हणजे स्वतःहून फोन केले की आम्हाला सरवटे सरांचं या विषयावरती लेक्चर पाहिजे. अशीच आपली सिरीज ज्याचं मूळ भक्त कुलकर्णी सरांनी लावलं त्याचा आपण आता वटवृक्ष करायचा वर्षभरामध्ये आपल्याला. तर याच्यासाठी तुम्ही पण आम्हाला जसं हे सजेशन दिलं की सरवटे सरांचं लेक्चर पाहिजे, तसं कुठल्या विषयावर तुम्हाला आवश्यक आहे तसे विषय पण तुम्ही आम्हाला सांगू शकता कमिटीकडे. त्या पद्धतीने आम्ही पुढचं आता ह्याच्या पुढची जी सुरुवात आहे ती मुळात आपण ड्राफ्टिंग प्लीडिंग याच्यापासून बेसिक आहे ते इथून करतोय. म्हणजे ड्राफ्टिंग प्लीडिंग आणि त्याच्यातले मग आपल्या फॅमिली कोर्टचे कायदे आणि नंतर मग ह्या आजच्या लेक्चरचा त्याला तुम्हाला अजून त्या पद्धतीनं उपयोग होईल. आता पुढचं जे लेक्चर आहे ते 3 ते 4 दिवसामध्ये अगोदरच ग्रुपवरती टाकलं जाईल. त्या पद्धतीने तुम्ही ते लक्षात घ्या. काल ई फायलिंग ट्रेनिंगला काही लोक नाव नोंदवलं पण काही जण आले नव्हते. तर ज्यांना खऱ्या अर्थानं खरंच ई फायलिंग ट्रेनिंग घ्यायचं आहे त्यांनीच नावं द्यावी, म्हणजे बाकीचं नुकसान होत नाही. आणि मग 24 तारखेला परत ट्रेनिंग आहे ते 24 तारखेला. तर त्याच्या आधी तुमची नावं बघत एकदा, कारण एवढा खर्च जवळपास जेवणावरती 500 रुपये खर्च होतो एका व्यक्तीला, तर तो सगळा वाया जातो आणि ट्रेनिंग त्यांना मिळत नाहीये. तर त्यांना खरंच नाव द्यायचं म्हणून देऊ नका. ज्यांना खऱ्या अर्थानं पाहिजे तशी नावं स्मिता मॅडम कुमार मॅडम कमिटीकडे द्या. तर त्या पद्धतीनं पुढे नियोजन करता येईल.
आपल्याला ते हे करता येणार नाही का थ्रू VC वगैरे, म्हणजे त्यांना इकडे समजा लिमिट असली तर, कारण वी वुड आल्सो लाईक टू कम सी ना.
हायकोर्टने सांगितलं इथे फिजिकल ट्रेनिंग
नाही नाही आम्ही रेकॉर्ड करतोय आणि माणसाचे ट्रेनिंगचे
हायकोर्ट इज सेंडिंग द ट्रेनर.
युट्यूबवर टाकतोय आता आजचं पण लेक्चर पण आपण युट्यूबवर टाकतोय.
लास्ट ट्रेनिंगचं पण टाकणार आहे.
हा एक टाकलंय
नाही, आज
आज टाकलं. सगळे लेक्चर्स पुन्हा पुन्हा तुम्हाला युट्यूबवर, आणि मागच्या वेळेस सरांनी सांगितलं की युट्यूबवर लेक्चर लाईव्ह दाखवतो की म्हणून इकडे यायचं थांबू नका, इथं आलेलं वेगळं पडतं ते. हा महत्वाचा विषय आहे त्याच्यात. अजून काय सजेशन्स असतील त्या आणखी एका ठिकाणी सांगतो, जे सभासद आहेत त्यांचा 12 ऑगस्ट पर्यंत विमा काढायची लास्ट डेट आहे. त्या आज आम्ही ग्रुपवर टाकतोय सगळे, तर त्याच्या आधी 450 रुपये तुम्हाला भरायचे आहेत. आणि बार काउन्सिलचा जो विमा आहे 11 लाखाचा, तो विमा 12 ऑगस्टच्या आत काढून द्यायचा आहे. नंतर मग वर्षभर पुन्हा त्याची मुदत लांब मिळत नाही. 4.5 लाखात 11 लाखाचा विमा मिळतो, तो आपल्या वकिलांसाठी, फक्त वकिलांसाठी आहे, तो एक काढून घ्यायचा आहे. एवढं लक्षात ठेवा. ज्यांचं व्हेरिफिकेशन राहिलेलं आहे त्यांनी व्हेरिफिकेशनचं 31 तारीख जरी लास्ट असली तरी आपण फक्त 20 तारखेपर्यंतच घेणार आहे. त्याच्यात 15, 16, 17 सुट्ट्या आहेत 4 दिवस मध्ये. तर 20 तारखेच्या व्हेरिफिकेशन फॉर्म सगळ्यांनी कमिटीकडे आणून द्यायचे. हायकोर्टला पत्र जबाबदारी आमची बार काउन्सिलला. आणि इथून आता एक्सप्रेशन मिळणार नाही हे सगळ्यांनी लक्षात घ्या. त्याच्यामुळे सगळ्यांनी आपले स्वतःच आहे त्याच्यावरती आपण काम करतो ते सगळ्यांनी आपली काळजीला सगळेजण द्या. ओके, परत एकदा सर्व सरांना धन्यवाद मागतो.